In this lecture, we would like to discuss another important current national, legal, and social issue, that is regarding medical termination of pregnancy, as because recently the Delhi High Court has allowed the medical termination of pregnancy of a woman who had completed 22 weeks of gestation, as the fetus was suffering from multiple abnormalities. So, in that connection, would like to discuss both the Medical Termination of Pregnancy Act 1971 and the Medical Termination of Pregnancy Amendment Act of 2021. So, gestation is the fetal development period from the time of conception until birth in India. The Medical Termination of Pregnancy Act stipulated a ceiling of 20 weeks for termination of pregnancy, beyond which abortion of a fetus is statutorily impermissible. So, the very key provisions relating to the act is failure of contraceptive method and opinion for termination, then upper gestation limit. Also, the fourth one is confidentiality. So, the Medical Termination of Pregnancy Act 1971 was passed due to the progress made in the field of medical science with respect to safer abortions, in a historic move to provide universal access reproductive health services. India amended the Medical Termination of Pregnancy Act 1971 to further empower women by providing comprehensive abortion care to all. The new Medical Termination of Pregnancy Amendment Act 2021 expands the access to safe and legal abortion services on therapeutic, eugenic, humanitarian, and social grounds to ensure universal access to comprehensive care. The key provisions of the Medical Termination of Pregnancy Amendment Act 2021 deals with termination due to failure of contraceptive methods or devices. So, under the Act, a pregnancy may be terminated up to 20 weeks by a married woman in the case of failure of contraceptive method or device. It also allows unmarried women to terminate a pregnancy for this reason. And the second key provision that we found opinion needed for termination of pregnancy, opinion of one registered medical practitioner for termination of pregnancy up to 20 weeks of gestation. Also, in case of 24 weeks of gestation, opinion of two registered medical practitioners are required for termination of pregnancy of 20 to 24 weeks of gestation, and opinion of the state level medical board is essential for a pregnancy to be terminated after 24 weeks in case of substantial fetal abnormalities. So, upper gestation limit for special categories or increases the upper gestation limit from 20 to 24 weeks for special categories of women, including survivors of rape, victims of incest, and other vulnerable women, differently abled women, minors, among others. So, the very nature of confidentiality relates to the name and other particulars of a woman whose pregnancy has been terminated shall not be revealed except to a person authorized in any law that is currently in force. And now we'll discuss certain significances and that we found preventable maternal mortality, so that regarding the new law will contribute towards ending preventable maternal mortality to help meet the sustainable development goals. So, to meet sustainable development goals, the sustainable development goal 3.1 is regarding reducing the maternal mortality ratio, whereas Sustainable Development Goals 3.7 and 5.76 relates to universal access to sexual and reproductive health and rights. The amendments will increase the ambit and access of women to safe abortion services and will ensure dignity, autonomy, confidentiality, and justice for women who need to terminate pregnancy. So, now we'll discuss the important issues involved in the very medical termination of pregnancy. And as regarding that, we found different opinions regarding termination of pregnancy. One opinion is that terminating a pregnancy is the choice of the pregnant woman and a part of her reproductive rights, while the other is that the state has an obligation to protect life and hence should provide for the protection of the fetus. Across the world, countries set varying conditions and time limits for allowing abortions based on fetal health and risks to the pregnant women. So, also, another important issue involved is not allowed beyond 24 weeks for termination of pregnancy. The Act allows a abortion after 24 weeks only in cases where a medical board diagnoses substantial fetal abnormalities. This implies that for a case requiring abortion due to rape that exceeds 24 weeks, the only recourse remains through a writ petition. So now we'll go to another issue of abortion. And regarding that, abortion to be performed by doctors with specialization in gynecology or obstetrics, as there is a 75% shortage of such doctors in the community health centers in rural areas. The pregnant women continue to find it difficult to access facilities for safe abortions. So now we'll discuss some other important points, that is critical overall assessment of the act, that is the medical termination of pregnancy amendment act of 2021. So it is commendable that the central government has taken such a bold stand while balancing the diverse culture, traditions, and schools of thought that our country maintains. However, the amendment still leaves women with various conditionalities, which in many cases become an immediate impediment in access to safe abortion. And in relating to that, we would like to discuss one important leading case, that is Justice K.S. Puttaswamy, retired versus Union of India and others in 2017. The Supreme Court recognized the constitutional right of women to make reproductive choices as a part of personal liberty under Article 21 of the Indian Constitution, which, despite laying a robust jurisprudence on reproductive rights and the privacy of a woman, does not translate into a fundamental shift in power from the doctor to the woman seeking an abortion. The government needs to ensure that all norms and standardized protocols in clinical practice to facilitate abortions are followed in healthcare institutions across the country. Along with that, the question of abortion needs to be decided on the basis of human rights, the principles of solid science, and in step with advancement in technology. Since it has now become an act, one can be assured that the country is on the road to advancement, addressing women issues more fiercely than ever. And now we would like to find certain differences between the Medical Termination of Pregnancy Act of 1971 and the Medical Termination of Pregnancy Act Amendment Act 2021. So, regarding the very indication, and that is relating to the contraceptive failure as under the Medical Termination of Pregnancy Act 1971, it is only applies to married women But in medical terminacy of pregnancy, Amendment Act 2021, it is applied to even unmarried women are also now covered under this act. And the second difference that we found in between these two acts relating to gestational age limit, where under the 1971 Act it was 20 weeks for all indications. But in case of the Amendment Act of 2021, 24 weeks for rape survivors, beyond 24 weeks for substantial fetal abnormalities. And the third difference we found on the ground of relating to medical practitioners' opinions required before termination. So, in the 1971 Medical Termination of Pregnancy Act, one registered medical practitioner, if the pregnancy is under 12 weeks or up to till 12 weeks, but in case of 20 weeks, the requirement was to ready registered medical practitioners till 20 weeks. But in case of the amended Act of 2021, registered medical practitioners for termination of the pregnancy if it is up to till 20 weeks, and two registered medical practitioners opinion if it is over 20 weeks to 24 weeks. So also the medical board approval after it completed 24 weeks regarding termination of pregnancy as under the Medical Termination of Pregnancy Act of Amendment Acts of 2021. And now we'll go to the fourth important difference between Medical Termination of Pregnancy Act 1971 and Medical Termination of Pregnancy Amendments Act 2021, and it is relating to breach of the woman's confidentiality in case that under the 1971 Act the fine was up to Rs 1000, but under the Amendment Act of 2021 it is both fine and for imprisonment of 1 year. So, this is all about medical termination of pregnancy, which is at present in India a national legal and social issue. So, it compelled the Union legislature to amend the Act of 1971 in 2021. So it provided some new provisions regarding the medical termination of pregnancy, and it increased the period for all such rape survivors. So also those substantially fetal abnormalities, and also it now covered, besides the married women, the unmarried women also are covered under the present amendment of 2021. So we have completed another most important current national legal and social issue, and that is relating to medical termination of pregnancy as provided under the vital acts of 1971 and the Amendment Act of 2021.